What's happening, everybody? We have excerpts from yesterday's oral argument before the Supreme Court for cannabis users' Second Amendment rights. If you want news like this, scan the QR code to get these videos to your inbox or subscribe for more videos about cannabis legalization. Now, we start with the best exchange, but stick around as we will go over all the justices, estimate the ruling, and even cover what they had to say about the federal marijuana laws. Let's dive in with Justice Gorsuch's hot takes. Let's get into it.
One can ask whether the habitual drunkard statutes are sufficiently, the how and why is sufficiently analogous. One could also ask, though, more basically, whether this defendant would qualify as a habitual user. And I want to explore that before we lose track of it. Habitual drunkard, the American Temperance Society back in the day said 8 shots of whiskey a day.
It's like half a bottle.
Only made you an occasional drunkard. We have to remember the founding era if you want to invoke the founding era. To be a habitual drunkard, you had to do double that. Okay? John Adams took a tankard of hard cider with his breakfast every day. James Madison reportedly drank a pint of whiskey every day. Thomas Jefferson said he wasn't much of a user of alcohol. He only had 3 or 4 glasses of wine a night. Okay? Are they all habitual drunkards who would be properly disarmed for life under your theory?
No, and again, I think this is something...
Okay, if they're not, then what do we know about Mr. Hamani? We know he uses marijuana a few times, about every other day. That's all we have in the record, right?
That's all we have.
Okay, so we don't even know the quantity of how much he uses every other day. What if he took 1 gummy bear with a medical prescription in Colorado? Well, you may not even need a medical prescription. You don't even need that anymore. But let's say he had one to help him sleep every other day. Disarm him for life?
Wasn't that interesting? Okay, so let's unpack several things that you're probably asking yourself. First, was whiskey basically the same as it is now? Yeah, it essentially was. A lot of the famous distilleries, they were founded a little bit after the birth of our nation. What is a tankard? A tankard, I had to look it up, is a big mug. So like maybe a pint mug of cider. Ciders, we still have them in bars. They're about 4 or 5% alcohol by volume. Now, you may be asking yourself, why were they going over what the founding fathers did? Because of a previous case, a case from about 3-4 years ago. It was New York State Rifle and Pistol versus Bruin. That was in 22. And in that aspect, for when you are applying a status-based firearm restrictions, that's what we have here in the Hamani case, a status-based. You are using marijuana. It is just a status-based. That's particular section. That's that 18 U.S.C. section 922 G3. That's what they're discussing here. And in that, they said that the Second Amendment must be consistent with the nation's historical tradition of firearm regulation. And so that's why they kind of dove into the habitual drunkard, which was 16, or basically like a whole 5th of Jack Daniels a day, as opposed to an occasional drunkard, 8 shots or half a bottle. And it appears that our nation's longest lived founding father, James Madison, who made it to the ripe old age of 85, even back then, had a pint of whiskey a day, which is in between there. So he's somewhere between an occasional and a habitual drunkard. And that's one of the reasons why they are using this historical standard. So if we were trying to say like, well, how do we think he's going to vote? Now, let's get into Justice Sotomayor and her analogies as she uses Ambien and also the historical tradition of these drunkards.
It showed that it incapacitated you. Now, it's hard for me to see how, given that drugs affect, there are different kinds of drugs with different kinds of effects, different kinds of duration. We have the illegal Ambien user who shouldn't be using the sleeping drug but is. We have a marijuana user that you say regular is defined by 2 or 3 or every other day, but how about the marijuana user who uses it only 1 day a week and not in their home where the gun is? I mean, there was a definition and a situation with habitual alcoholic users that's different than this.
you heard right there where Sotomayor was drawing clear distinctions on it. And that makes me think, well, maybe she will also be in the no camp. Moving on, let's go to Clarence Thomas, zeroing in on making a distinction about marijuana.
We're addicts, not illegal users, but well, I'll wait till my seriatim rounds.
Thank you, counsel. Justice Thomas, anything further?
You seem to rely quite a bit on the illegality of the marijuana.
Yes, but not exclusively. I think it's post-ratification history, illegality, and the way the Controlled Substances Act works to make determinations, plus the temporary nature of the restrictions. So
What about other unlawful or illegal drugs, such as anabolic steroids?
Anabolic steroids, I believe, are either Schedule 3 or Schedule 4. So I would give similar answers to Justice Barrett with respect to my front line and my backup. I think the front line is there are the same kind of judgments that are being made. My backup is if there are concerns with respect to how you go sort of down the schedule, the government only cares really about prosecuting Schedule 1 and Schedule 2. And that's the tightest level of determinations. You have to find a serious danger of abuse, and any sort of alternative approach is going to throw out the heroin, the fentanyl, the ketamine, those kinds of things.
So other than the danger of abuse, does there have to be some sort of implicit danger in the drug, the effects of the drug itself?
That is usually part of the scheduling determination. So it includes the addictiveness, but also you can look even at the recent notice of proposed rulemaking with respect to marijuana, mentioning that DEA in this process normally comes forward with public safety evidence with respect to other risks. And so that is part of the calculus, and I think is pretty tight in it.
Thank you.
And so you can see how Clarence Thomas dug into the distinctions that are happening between, they're only doing this for marijuana. They aren't doing it for anabolic steroids. And then the government's own attorney mentions the notice of proposed rulemaking and the rescheduling process currently underway with the DEA. Okay. All right, now let's do Justice Alito. He is in the no camp. See if you understand and can spot why he's in the no camp.
Most of the most commonly used illegal drugs either had not been invented at the time of the adoption of the Second Amendment or the adoption of the 14th Amendment. Heroin was invented in 1874, cocaine 1855, methamphetamine 1893, fentanyl 1959. Marijuana existed, but my understanding, hemp was grown for industrial purposes. My understanding is that it was not consumed to any degree by people in the United States until at least the beginning of the 20th century. Is that consistent with your understanding of the situation?
That is correct.
So we don't know what the founders, what those who adopted the First Amendment or, the Second Amendment or the 14th Amendment thought about illegal drug use per se.
Correct.
Can you see the difference there? Some of the other justices are pointing out the hypocrisy. Justice Alito is saying, well, we have no idea what the founders actually thought about drugs. Okay. Now, let's go from that one to somebody who may be on the fence, and I'm not sure how he's going to vote. We can look at other jurisprudence that has come down from the Supreme Court regarding the Second Amendment to guess, but we'll do that in a minute. Let's move on to Judge Kavanaugh.
Why are they not in the heartland of an addict? So just parse that out for me.
Because it is not clear whether Mr. Hamani could voluntarily cease the conduct. Addict is defined by sort of an internal compulsion to use. An addict can include someone who isn't actively using right now, but has an uncontrollable compulsion to use whenever they get access to
So
the
is
substance.
addict misdefined in the Controlled Substances Act then?
It's defined correctly for the purposes of that act, but Congress did not port that definition over into 922G3 because, again, the only thing it ports over is the controlled substance. And this is not sort of an unusual view. It's what the Court of Appeals have recognized based on the dictionary definitions, that this is an overlap, that may well be overlapping categories of people, but we're giving them distinct meaning, and that this is something that constrains the government in prosecutions, and an unlawful user is judged by a high frequency of use. That's the objective test.
Let me, on a different front, mens rea. How does mens rea work here given rehave? What do you have to prove that the defendant knew about habitual?
Here's what you have to do. One, you have to know that you're using an illegal drug. And I think that's an important constraint just right out of the gate. Two, you have to know that you're using with how many times you're using it. You don't, in the government's view, have to know the legal definition of habitual, but you do have to know, like, if I use marijuana 4 times a week, I had to know I use marijuana 4 times a week. So the conduct that would put me in the category of habitual, I must know. I think these are virtues of the approach here. The government doesn't normally like Rahave a lot, but in this particular context, I think it helps impose meaningful limits to the extent the court is concerned with how broadly unlawful user goes above and beyond the constraints courts of appeals have identified. And this is something Chief Judge Colleton also pointed out. The knowing requirement does work here. That is important.
Do you think the government could prohibit a habitual drug user from owning a car?
Owning a car with, I think that, I guess there would be various, there would be various challenges with respect to taking as and other types of property. And I think you would have a different, probably not, but the question for Second Amendment purposes is a different one, which is, are you someone who presents a special danger of misuse in that tradition? So for takings purposes or whatever else the constraints are in that.
It's a danger to have drug users obviously driving cars.
And I don't think you would find a history and tradition.
Well, there you go. He's poking holes at it because, like, this is the Second Amendment. This isn't a tradition of history of, like, being able to own a car. A car is a privilege. Being able to drive is a privilege. They aren't taking away that privilege, but they are taking away your Second Amendment right. This is one of the reasons why I think Kavanaugh may swing and be in the no camp. I could be wrong. We'll find out in a few more months. Now, in that exchange with Justice Kavanaugh, you've heard attorney or counsel Sarah Harris, the state's attorney, arguing that the knowing of the illegality is actually a component of what the government is arguing to try to take away the Second Amendment rights of habitual cannabis users. And so it's interesting to now listen to this exchange with Justice Gorsuch about that one prong that they talk about, knowing that it is illegal and that is important.
There's more. Sorry.
No.
922 G3 has 2 prongs, as we've discussed. One is you're an unlawful user, and second is you're an addict. And you prosecuted Mr. Hamani only under the first prong, unlawful user.
Correct.
You're asking us now to understand that prong to mean an habitual user.
Correct.
What's left of the second prong? Do you render it superfluous, given that an addict is defined by the statute as an habitual user?
So 2 pieces of this. One, it's not superfluous. An addict is someone who has an uncontrollable urge to use this substance, regardless of whether they have access to it at a particular moment in time. You can be an addict and not be an unlawful user because, for instance, you're in a treatment.
I thought the CSA definition of an addict was any individual who habitually uses a narcotic drug so as to endanger the public morals, health, blah, 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 blah.
Yes. So the second part of this is, I think respondent is being very careful to say, we're not actually, no one thinks that that is the actual operative definition. I don't think you could, because it says narcotics. It is obviously not the definition that Congress is using. It's limited to narcotics for the purpose in the Controlled Substances Act of dealing with treatment facilities. So the ordinary meaning that's been adopted by the government with dictionary definitions and all the courts of appeals is not that. It does cover both concepts. It covers unlawful user is someone judged by the objective criteria of their frequency of use. An addict is someone who has an uncontrollable urge. They can overlap.
And then secondly, your backup argument is, well, maybe Schedule 1 and 2. We really need those, but not Schedule 3 and the rest of the schedules. If that's the case, what do we do with this case, given that, yes, it's presently a Schedule 1 drug, but the government itself is considering rescheduling it to a Schedule 3 drug? Why bring this case? Why is this the test case?
Why is this the test case? I mean, one is that, first of all, at the time when the offense was committed, marijuana is and was a Schedule 1 drug. 2 is the government has not made final decisions with respect to what to do with marijuana. But I think something that is clear from the NPRM, at least, again, bracketing like what happens in ensuing stages, is that even Schedule 3 drugs, which include things like ketamine, the difference is they have some medically accepted uses, not that they're not dangerous, not that they don't present.
No, I understand that's your primary argument, is they all count.
That's
your backup argument is we'll stop at Schedule 2. I don't know why, but okay. But the drug that is involved in this case might wind up being a Schedule 3 drug tomorrow.
Yes, I understand that. And I think what I'm saying is not so much there's like a hard and fast, like special magical Second Amendment rule that says Schedule 2 and no further. It's just if you wanted to sort of if you wanted to rule out like Schedule 5 or Schedule 4 for Ambien, the cutoff with respect to dangerousness like does diminish. And I think the court could say you could bracket potentially as applied challenges if you wanted to do that. I'm just saying this is a fallback. That's not the government's main position, but I think when you see the way the scheduling works and the statutory
No,
criteria,
I understand that. It's just an odd case to have chosen to test the principle when the government itself is potentially rescheduling it as a drug that it wouldn't think would qualify under at least its backup argument.
There you go. Very interesting questions, and talk about being peppered and grilled by the court. Why should I vote in favor of this law if your backup argument is going to be completely off the table tomorrow? And then you juxtapose that with Kavanaugh's poking holes at it. It's like, well, can we ban them from driving a car? And driving a car is not your Second Amendment right. That's also interesting that even though they are rescheduling the cannabis plant into a better schedule than Schedule 1, they're still arguing, and by they, I mean the United States, is still arguing that we could take your rights away from it. Okay, so we've covered quite a few of the justices, but we have not yet gone to Justice Barrett, who has a really interesting analogies and other questions, and she follows similar strains of questioning as many of the other justices who give you the impression that they are suspect of the government's actions in this case. And you're going to see her drilling into something that comes from a case from a few years ago, the Rahimi case. This case is Hamani. 2 years ago was Rahimi, and Rahimi, that's where this habitual drunkard, it gets into whether or not the disarming of the person has to do with if there are credible threats or special dangers of misuse. And so Justice Barrett is going to kind of drill into this. Well, where's the dangerousness aspect of this drug? Has there been any evidence of this dangerousness aspect of it? So there is some justification to curtail your Second Amendment rights. Let's go to that.
Of that for winding up on one of the schedules, there are a panoply, and you can wind up for one reason and maybe not for another. Is proclivity to violence expressly one of the things that's taken into account in putting a drug on the schedule?
It is not in the statutory criteria. The way I do think it often works out is the DEA may provide evidence with respect to the drug in connection with crimes, but obviously it's not one of the fixed statutory criteria. Again, I don't think that's a problem for the reasons we've discussed, which is you also don't have findings with respect to the mentally ill or other categories.
I mean, I understand that. I think where I'm stuck, I agree with you that you don't need to have just alcohol because that's all there was at the finding, and that would be trapped in amber. Let's say that I think that the principle is if you have reason to know that someone would pose a risk of violence is dangerous, that the legislature can disarm. I guess when I look at these drugs, however, I mean, Robitussin, Ambien, Tylenol with codeine, testosterone, Adderall. I mean, none of those drugs strike me. I mean, I'm not a pharmacologist, but none of those drugs strike me as drugs for which it is obvious that a risk of violence would ensue. Is it your position that all of the drugs that I just mentioned would pose a risk of violence and dangerous behavior?
So what I'm saying is those drugs in Schedule 4 and Schedule 5.
Well, actually, Adderall is in Schedule 2.
Okay. Just with, yes, I'm sorry, I'm less familiar with Adderall on the scheduling. But with respect to these categories of drugs, whichever schedule they're on, you have to be using them habitually and not for their prescribed purpose. So yes, our position is if you are in that category, you are doing something that is.
So it's the lawfulness, because what if you're a college student and you take your roommate's Ritalin twice a week because you think it's going to help you take exams?
Yeah, and I think we're going to get to a place where you're into ketamine and other drugs, ketamine being Schedule 3, it's a lesser version of PCP.
So the problem is that if you take Adderall, then you slide into other drugs?
I think it is a problem of who decides what the adequate proxy for dangerousness is. And if you wanted to go on...
But you said, and I think it's clear when you look at the Controlled Substances Act, dangerous is not necessarily the primary reason why, or even a reason why all of these drugs land on the list. And so I guess my concern is, let's say that I think Congress could make a determination, maybe, I don't know. I mean, there was just an article in the New York Times about the dangers of marijuana, and, maybe that's true. Maybe THC concentrations are higher nowadays, and that does have bad effects on bad mind altering effects, and maybe it gives rise to violence. I just don't see that. My concern, and maybe you can dispel it. My concern is I just don't see that that determination was made here.
I guess I would point you to
And there you go. She's really drilling in as to the dangerousness aspect of the case from 2 years ago. I've already gotten them confused. Because they're really close. Hamani and Rahimi. And so Rahimi clearly is what Justice Barrett's getting into, and she's trying to make sure that there's this special danger, this credible threat, something is going to go wrong. And she's saying, well, all these schedules on these drugs, they really don't get to the dangerousness aspect of it, and drawing that distinction there. And of course, the categorical ban of all unlawful users. You can't. That's the case. The other case from 22, the Bruin case, where these categorical bans are a little bit too broad, and then Rahimi is the exception to that when you have the credible threats of the danger of violence. And Justice Barrett's just like, look, I don't see it. You aren't showing it to me. That's one of the reasons why I don't think she's going to vote to uphold the application of Section 922G3 in this instance. Now, who's next? Let's move over to Justice Sotomayor, again, drilling into the dangerousness aspect of it.
Was not merely the fact that they were using an intoxicating substance. The way the habitual was defined was that the state of intoxication didn't permit you to have a regular life. All the definitions around habitual alcoholics centered around not merely taking the drug, but the potential effect it had on you because you couldn't control it and would continue to use it. You were acting responsibly towards your family. You were sleeping in the streets. You were doing other things that showed that it incapacitated you. Now, it's hard for me to see how, given that drugs affect, there are different kinds of drugs with different kinds of effects, different kinds of duration. We have the illegal Ambien user who shouldn't be using the sleeping drug, but is. We have a marijuana user that you say regular is defined by 2 or 3 or every other day. But how about the marijuana user who uses it only 1 day a week and not in their home where the gun is? I mean, there was a definition and a situation with habitual alcoholic users that's different than this.
So
I'm not going to let her respond, but you can catch the whole thing. I'll put the whole thing in the description down there. As you can see, they're drawing distinctions and they're zeroing in on like, well, this isn't a habitual drunkard. They aren't void. They aren't drinking a bottle of Jack a day. And your definition of habitual is pretty loosey-goosey. And then it doesn't seem like the dangerousness is there either. And now, why don't we we have Ketanji Jackson and Lega Kagan to go with next. The Bruin framework, I think, would really help. And Justice Jackson drills into the Bruin framework. And that's important because that's the exception to the categorical ban problem. And then the exception has to do with the dangerousness. And so the justices are asking their questions, knowing the precedent that they're being asked to elaborate on.
moderation.
And Ms. Murphy, I thought your point was that even if it did, deferring to Congress with respect to that kind of judgment is what Bruin tells us we're not supposed to do. That you would be abandoning, in a sense, the Bruin test to kind of take the Chief Justice's, what I think, reasonable view of thinking about what Congress has said and assessing what Congress wants to do and evaluating whether it's doing it in a narrowly tailored way. If we're doing that, then what work does the historical analog have to do? I thought we had to look at the historical analog to constrain Congress in its ability to disarm people today.
That is exactly, that is our core submission. And the government said multiple times today that they agree that they have to actually map onto a historical tradition.
And so the question is, how does that mapping happen? At what level does that mapping happen?
Sure.
And I hear the government saying it happens just at the level of the old cases were looking at people and making judgments about when they were dangerous and should be committed or whatever. And it can't be that broad, I think.
We certainly don't think it can be that broad. I think it has to be attached to a principle. So the principle in Rahimi was not simply Congress decided certain people were dangerous. The court focused in particular on the fact that part of 922G required an individualized determination of dangerousness. Now, we're not saying
and I realize that was just Justice Jackson, but they're all asking questions regarding the same thing. Who is the one that we haven't gotten to? But we are going to go to Justice Kagan that does an interesting hypothetical regarding a hallucinogenic drug to also drill into the concept of dangerousness about it. And, she doesn't really mention anything about rescheduling, but, just what the facts are regarding what the law is and how you need to have this dangerousness aspect to be able to be disarmed in compliance with your Second Amendment rights. Let's see what she had to say to Attorney Murphy, who is Hamani's attorney that was arguing before the court.
You don't know a lot about this drug, so what I'm going to tell you about this drug, let's just assume is the truth about this drug.
fair enough.
So the drug is ayahuasca, and it's a very, very, very intense hallucinogen, and the episode lasts a very long time. But it's not, let's say, an addictive drug. You can choose when to take it. But when you're in its grip, you basically, reality dissolves, all right? And I'm assuming that Congress has a good reason for saying when reality dissolves, you don't want guns around. But that, to me, when you give the description of the historical analog, to me, that's going to fail your test. Should it fail your test?
I'm not necessarily. I guess I would say two things. First, obviously, we agree that you can be prohibited from carrying while you're taking that drug. But I don't think I don't think it's
a question of carrying. It's like, there you are in your house. You have a gun in your house as well. So you're owning a gun, even though you use this drug, let's say, once every 2 weeks.
Yeah, I think that it would be a little bit difficult to show that really using that drug every few weeks is going to be enough to render you akin to the concept that the historical drunkard laws were getting at, which is that your consumption rendered you, we're not saying that you had to be intoxicated all the time, but your consumption impaired your ability to function, even your moments of sobriety. That's what the courts are talking about. They're asking whether it doesn't have to be addiction. It can be addiction, certainly, but it could also be you're consuming so frequently that, that's really all you do. And during the day,
so
you're not
definitely, so it's definitely going to fail your test.
It may not. I think, you'd have to look
on my
at
facts,
what the lasting,
right?
how lasting the impact is. But if a person is, if what you're essentially saying is there's a substance that leaves a person impaired once every 2 weeks, but the other 13 days of those 2 weeks, they are perfectly fine. I don't think it's consistent with the historical tradition the government has invoked, just as I don't think that tradition would support incarcerating that person, subjecting them to guardianship, or committing them to a drug treatment facility.
Well, what if you personally?
I was just going to say that the hypothetical focused on a particular time period, but I think it could be used every week, not just every third week or every other day. And again, I think that's something with the judgment about that. You said that's going to be made in court.
And that kind of judgment gets made in court all over the country all the time in the hearings that are routinely held to decide whether somebody can be subject to things like guardianship or civil commitment because of their substance abuse.
Well, but they're made under the determination set forth by Congress and the executive in statutes. You don't, if they want to categorize this particular drug as something that's dangerous, that's not enough for you.
Well, that's not enough for the types of civil.
And there at the end was Chief Justice Roberts, who doesn't appear to be on board. And if you go through Justice Kagan's hypothetical regarding ayahuasca, it also doesn't seem like she's necessarily on board. So what might the ruling be? They'll be under advisement for several months, and then we'll probably give us something by the end of June at the latest. It was a really great hearing. I had a lot of fun listening to all the arguments. What do we think after going through each one of the justices that they're going to vote for? It may be a 6-3 or a 7-2. I don't know if Kagan is going to join. She seemed like she was on the fence or maybe even leaning toward no, but Gorsuch, Sotomayor, Thomas, Kavanaugh, Barrett, Jackson, they were pretty firm, leaning towards no, that this is unconstitutional. You can't abridge someone's Second Amendment rights this categorically. So that leads to a 6-3, where you have Alito, and then you have Chief Justice Roberts, and maybe Kagan joining them. Maybe not. I'm not particularly sure. Maybe it'll be 7-2 if Kagan is convinced. But these people don't have a lot of experience with the cannabis drugs. I know that Mr. Kavanaugh does like beer, but he seems like he's on board. Anyway, what did you think of the oral argument in the case of Rahimi? Do you think that the cannabis users will have Second Amendment rights? I want to hear from you. Leave it in the comments and tune in on Sunday for our next cannabis legalization news podcast. The federal shift towards Schedule 3 doesn't rewrite your license strategy. Having the right dispensary footprint and operational playbook in place before regulators fully implement that new policy. That's where Collateral Base comes in. We help cannabis businesses win dispensary licenses, structure compliant operations, and manage stores. Link below. We help clients navigate licensing, compliance, and operations so they win in the new regulatory era.